tell myself and the public the future plans and agencies involved in this future development. The agencies should be the ones putting in the money for this and not the taxpayers, as the taxpayers have already told the commissioners they don't want their tax money spent on this building. The agenda states to have a stipulation to pay the county back from the sale of the COA property. I think Bob addressed this, I think it was 2 meetings ago, that the county owns this property. It's not COA property. The COA is a county agency that operates off of this county property, so there is no repayment from the sale of the COA property. Any repayment would be from the agencies from your future development. I'm not sure how that even gets there, but if that goes through as a resolution, it really muddies the water for future commissioners and stuff, and that really needs to be addressed. There's also $3 million that was given of taxpayer dollars towards this. That should also be considered in the repayment from the sale of this property. But as I said, the biggest thing is, why are we not contacting our House reps to deal with MDOT if MDOT is really the problem? Having been part of a build last year, an approved driveway was one of the first things you had to have. So I'm not sure why or how there was no approved driveway before the permit was approved and issued. So that, that needs to really be answered. Was it the failure of Berry County? Is it really an MDOT issue? And why are we footing the bill when Mike Calton at Maple Grove Township said that the donations for this building were very high over their goal? So have you seen a financial statement from the COA saying that they don't have the money to build this, to finish up? And it was really their responsibility to ensure that they had the other funding and that the taxpayers weren't going to be breached again, or that the taxpayer checkbook wasn't going to be breached again. You have a jail to build and you keep on finding ways to spend money, and that's still not being addressed. The other thing I do want to say, Isabella versus Pung, arguments are going to be heard tomorrow at the state Supreme Court. There is probably an issue there, as there are not all counties. Berry County was not the only one that did not support these fundings. So why that was said, well, I don't know, was it just meant to belittle you, the county commissioners? Thank you.
Thank you. Additional public comment?
Morning. Courtney Zinni. I am a City of Hastings resident as well as the Executive Director of Commission on Aging. We just wanted to make sure that we were here today to thank you, the Commissioners and the County Administration, for continuing to look at our project as a collaborative project. From day one, that's what we've really looked to it as being. We continue to see it as being that. We are grateful for the dollars that have been put towards the project already. We are grateful for the community who has also raised over $3 million, $3,074,000 and some odd dollars at this point. So we are thankful to see the project continue to move forward. The reason for the move of the drive was to continue in that collaborative aspect. And I know that's easy for me to say, having been part of the 18 months of conversation, right, and the back and forth. But just we could have the drive where the drive is, but that doesn't help the county in the long run. What does the long run look like? We don't know, right? But if we want to look at collaborative projects in the future, once the jail is resolved, then we do need to look ahead to that and not be short-sighted. So we appreciate the opportunity, and thank you. And I don't know if you guys have seen it yet, but if you haven't driven by lately, please drive by. It's super exciting to finally see the entire building outline. So grateful for those that are working hard even in the cold weather. So thank you.
Thank you. Additional public comment? Hearing none. Approval of the written agenda. At this time, any member of the Board of Commissioners may ask for an item be removed from the consent agenda and placed under items for consideration. Hearing no such request, does any commissioner wish to change the agenda additionally? Hearing no such request, the agenda is approved as written. Various correspondence. Does any commissioner have correspondence they'd like to share with the board? Hearing none. Consent agenda. Commissioner Getty.
I move for the approval of the February 10th, 2026 Board of Commissioners meeting minutes.
Is there support? Bassett? Okay. Motion by Getty, support by Bassett for all items listed on the consent agenda. Discussion is not allowed and a roll call vote is required. All those in favor vote aye and opposed vote nay. Madam Clerk, would you call the roll?
Bassett?
Aye.
Carlson?
Aye.
Campbell?
Aye.
Getty?
Aye.
Smelter?
Aye.
Tennyson?
Aye.
Hatfield?
Aye.
Mayor Jackson?
Aye. The consent agenda is approved. Presentations, we have none this morning. Public hearings, we have none this morning. Items for consideration. The chair would entertain a motion for approval of claims in the amount of $107,160.31.
So moved.
Support.
Motion by Smelker, support by Tunison for approval of claims in the amount of $107,160.31. Discussion? Madam Clerk, would you call the roll?
Carlson?
Aye.
Campbell?
Aye.
Getty?
Aye.
Smelter?
Aye.
Tennyson?
Aye.
Bassett?
Aye.
Hatfield?
Aye.
Mayor Jackson?
Aye. The motion is approved. Next on our agenda, Jeff, good morning.
Good morning, everyone. Jeff Kiesler, Planning and Zoning, here to talk about compassion homes. So on the January 26th Planning Commission meeting, the Planning Commission voted to approve compassion homes as a special land use in rural residential and agricultural zoning districts. And you should all have received a red line text document in your packet. These are the changes that we would make and the different areas of the zoning ordinance where we would make them. And I'd be happy to go through those. I did get some feedback from Commissioner Getty this morning about a couple of different items that I'd like to bring your attention to, if that's okay. Down below in section 2318, compassion homes, at the first point, we say compassion homes are permitted as a special land use in agricultural A, rural residential RR districts, and/or other appropriate residential districts as determined by the Planning Commission. Quite often, we leave a little bit of room for ourselves to maneuver, but I did get some feedback on this comment that it really is vague and a little bit confusing, and the feedback was that we should strike and/or other appropriate residential districts as determined by the Planning Commission. So that's one point, and then point 7 on the back side, we say the special land use permit shall be reviewed periodically, e.g. every 3 to 5 years, or upon change of ownership or operation. Again, the feedback was that that was a little bit vague, and that we should just pick a time to review and state that. So those are my comments about that. And I don't know if you can approve with those changes, or if we need to send back to the Planning Commission to approve those and bring it back before you.
Commissioner Getty, any other input?
No, I think that reflects my comments. I had a question after we talked about special uses, and if there are set periods upon which other special uses are reviewed, that this could be consistent with, or if I imagine that the special uses, will be inspected from time to time.
Depends,
So,
but yeah.
If there was something that was out of compliance with the standards under which it was approved,
Yeah.
that could be addressed, but just to require them to come in for review, if that's consistent with other special uses, I'm okay with it, but if it's
Not typically.
specific just to this one,
Yeah.
then I would say I would rather be consistent.
I hear that. So as far as, the motion, or however we do this, do you think we need to go back to the planning commission to have those changes approved, or?
If you have substantive changes, I would recommend the commission send it back for planning commission to consider.
Yeah, I agree with that as well. Since the planning commission is bringing us before us, I hate to make changes to it without their approval.
Yep.
You know, that they can review that and see, and those are good points, so.
Okay. And one other thing I wanted to mention, we have on our zoning board of appeals, Shirley Barnum, who has been with us, I think, for 19 years. She has decided to step down. The comment she made to me is, I think I'll be 95 when when the term would be over. So we're losing Shirley Barnum, and we're losing another Philip Joseph as well. So we'll have 2 members on the ZBA as of April 1st of this year. So I am kind of putting out a little bit of a plug for ZBA members. So that would be folks who are, handling appeals, variances, hashing out the zoning ordinance and what it means for people. We do need a couple of members for the ZBA, so just putting in that plug.
Awesome. Do we need a motion to table this, or can we just?
Good question. Are we holding them up pending our action on this?
We are not, no.
My recommendation would be to have a motion to return the ordinance to the planning commission with the changes to be considered. You will likely have to re-public hearing this because it's a change in ordinance. So that would be my recommendation at this time.
Thank you.
I think it's pretty clear in the act that's how it would work.
The chair would entertain a motion to send the requested, where did it go? Oops. Do you have questions?
I was just curious why we can't just table it.
Well, they need to make the changes that are in the zoning.
The Planning Enabling Act is very clear that the commission, once it's approved, you have the ability to send it back to the planning commission, you have the ability to approve it or deny it. So there's really no tabling of it. I think the motion is to send it back to the planning commission with the recommended changes, and then have them revisit that, and then update it, and then send it back to you.
Okay. The chair would entertain a motion to send back to the planning commission the recommendation for allowing compassionate homes with the changes that were identified this morning.
So moved.
Support.
Motion by Getty, support by Bassett. Any additional conversation, discussion?
The only thing is, if you could define and at least explain what a compassion home is.
Yep.
For those that didn't get the packet.
Absolutely, yep. I'm going to read the definition, just give me 1 second, all right. So, and by the way, I appreciate your support too, so. A compassion home shall mean a residential facility providing a home-like, peaceful environment for terminally ill hospice patients surrounded by loved ones, similar to a hospice residence or end-of-life care home. A compassion home requires that residents be under the care of a licensed hospice agency and does not include on-site medical doctors or acute medical care facilities. So this is end stage of life, and the way that they explained it to us was if there is treatment going on, then you're not in end stage of life. You're being treated. So yeah, that's the definition that we have.
Okay. Mr. Calton?
Just want to understand it more. So, a compassion home, is it for like one person at a time? Or can multiple people be in that home?
So good question. We have 6 as our maximum right now, and that is on the advice of both Serenity Village and also Will Mattson, who is on the Planning Commission. He is in this world for his employment, and that was his suggestion as well. Getting any more than 6 families in there at once, would be a little kind of chaotic, and that's not the environment that they're trying to make. So, if you had 10 or 15 families moving around and bringing things in and out, it's not a peaceful environment. So,
So does this look like a house, or does this look like a nursing institution? What does it look like?
so Serenity Village is up just north of town. It used to be a veterinary clinic, and I don't remember the name of it, but,
It was Bull Creek.
Bull Creek.
okay. So it looks,
One of the things that we struggle with at Planning Commission is, we're not approving this specific facility.
Thank you.
We are approving compassion homes in general. They could look a lot of different, they could look different. I mean, it could be a converted house. Yeah, it could be, look more like a commercial building.
right.
Yeah, it is a type of use where we're not dealing with just this one application. So this one application is the old Bull Creek, veterinary clinic, so it is more
Commercial building.
looking than it is residential.
Yeah.
But it still is an attractive facility.
Yep.
It's well isolated. So I think that it is certainly an acceptable use in that area. And that's what, by making this a special use, there's always going to be that kind of review. Is this use consistent with the area in which it's being built? Is it going to in any way harm the character of that neighborhood? Special uses should not do that.
Right.
So,
So in terms of special uses, I mean, this can't be called like a care home or something that's already in there? I mean, this needs its own designation? It's a compassion home?
Because they want their facility to be unlicensed, they're working with licensed hospice staff, but they want the facility to be unlicensed. That's requiring the extra designation, yep. Because anything that we would have in there right now would not be what they're trying to do. It would be more of a medical setting. Yeah.
Okay. Any other questions or comments?
I was gonna just make a comment. It basically, what Serenity House is all about, Mike, is like, someone might just possibly have a week or two left. It's not like a long-term facility at all. It's more for, like, you're taking care of your loved one and you know that they're terminal, and you just can't take care of them in the end stages. And that's what that compassion home idea comes into play, is why it's kind of named that way, because that's what it is.
Yep.
You're compassionate on the fact that they're have a short time on earth left. Okay, so that's what it's all about. It was the idea behind it, was to help people with their loved ones who were, in a position where they could not do anything for themselves.
Okay,
So-
thank you.
Thank you all.
Okay. There are no further questions. All those in favor say aye.
Aye.
Opposed? The motion carries. We will see you in a couple weeks.
Okay, thank you.
Thank you. Eric?
be a little longer than that, because we just met last night.
Oh, yeah. Oh, okay, so Eric and/or Courtney, whoever wants to work with us on the next item.
Probably a tag team. In your packet, you have a request for spend up to $200,000 to cover the cost of moving an expanded driveway for the county property out on M79. The location where the driveway is proposed at this time, as we were looking through it, working with MDOT through all the regulations that they have, and the original driveway, which is supposed to go out there now, MDOT has now added the fact that you need passing flares, a decel lane, and then turning right for westbound traffic. So they've added some things that were not anticipated in the original budget. Whether right, wrong, or indifferent, I think it's an overstep, but I'm not the regulatory agency when it comes to this issue. We're responding to the regulatory agency. As we were looking at it,
if there is a potential for development of the rest of the property to the west of Harvest Point, where the driveway is at currently now does not make sense. There would be substantial need, I don't even know how you would easily get it out there. You'd have to go through the driveway at COA and then out to the west. So making this change now, moving it to the west, moving a little further away from the intersection makes sense in a lot of ways. But there's additional cost at that point. So that's why you have the request in front of you right now. I know this has been talked about we've gone back and forth with MDOT, we've gone back and forth with the committee, and this was the current proposal that we have for you to consider.
I think it's important, just to add on to that, we've been dealing with MDOT for probably over a year on this. And when we started talking about the driveway location, MDOT's response was, you don't need a driveway.
Right.
So we thought it was very important that this facility have its own identity, its own driveway, its own location. So that was the first fight. So then when we got the approval for the driveway, then they said, however, you're going to need passing lanes on both sides, which if you've driven M79, there are flares and decels, but there are really no passing lanes anyways, which we didn't think it made sense to have people driving by our seniors at 60 miles an hour when they're trying to turn in. So we continued this discussion, and as we looked at this and looked at the location, they allowed us to use flares, which are the least expensive option, especially if we would move it a little further down. That also opened up development for the remainder of the property. And at a cost of $200,000, the COA is still picking up a large percentage of this cost. It's not being paid for in its entirety by the county because they already had budgeted for a driveway. We just didn't anticipate the tennis match we were going to have to get to this point with MDOT. So in looking at this, if we can spend $200,000 in 2026 dollars, if the development is in 2 years or if it's in 10 years, that cost could be $600,000 or $1 million in the future. Just makes sense if we're going to have access to that property. We've already had proposals for additional senior housing. That there's a tour going on here in a couple weeks, that there are other opportunities that they were talking about with trails and things like that. But to put it in the original location really handicapped any future development. And MDOT did come out in that conversation and say they don't want any more driveways. So if we decided in 10 years we wanted to put an additional driveway in, they pretty much said, no, you can't have another driveway. So it made sense to think long-term about this versus pigeonholing ourselves with one access point. So, I mean, is that fair?
That's fair. And MDOT, when it comes to their decisions, are very factual, facts and based. They based everything on standards that they have, which we don't necessarily have to agree with them, but that's how they're going to make their decisions. We did go up the chain at MDOT to the regional manager and the TSC manager, and we got the same answer. Basically, we got the ability to have this, the passing flares as an option. They were willing to bend that far, but that was about as far as they're willing to bend at this point. And in my experience with MDOT, which has been 28 years working with them now, that's consistent with their approach everywhere. I've worked in multiple TSCs, and we felt this is probably as good as we were going to get at this point.
Yeah, we won't even bring up the traffic study because the traffic study said one thing and MDOT did another thing, but they are their own country, so we really can't dictate to them what to do. And we have gone up the chain of command as far as we could go with them. But so anyways, it was reasonable for us to split this cost for future development, making it easier for the COA and traffic, for our seniors, and the potential development for that. It was just dollars well invested at this point, which I think will easily recoup going forward. So, questions? Commissioner Tunison.
Well, when MDOT changed the game as far as when we found out we could only have one access to that whole property, it changed the game, right, that we needed to move the driveway more to the west so that we have access to all of it, not just COA. And then that way you can flare off and go to the COA, you can flare off and go wherever you want at that point. But once they said, the temporary driveway, you're only gonna have, that's way down by McEwen Road, and you're gonna have one cut in that whole road. It kind of changes the fact that we needed to move it to the west and be able to utilize it all. Otherwise, you know, how are you gonna get to it going through, you'd have to tear up their parking lot or go through their parking lot to get to the rest of it. It really didn't make much sense.
Absolutely. I think Commissioner Getty, you were at that meeting too. I don't know if you had any other take on that.
I agree with, with Eric. It just, MDOT is not very responsive to compromise or practicality, it seems. So this is better than having to go through the Harvest Point driveway, which was where we started.
Absolutely. Additional questions or comments from commissioners?
Yeah, I've got one more about, as far as, you know, it's different, right? If the fact that they're building a new building, we have the ability to sell that property up there where the current location is, right? So, that's one reason why I would support this, is the fact that we can pay this back. And we can take the proceeds and put it in the building fund or whatever else after, up and beyond the 200,000. As long as it's in the language, right? So.
Yes. Additional questions? The chair would entertain a motion to approve up to $200,000 to support the change in the driveway location to allow for future development at the county property west of Harvard Point, with the stipulation that proceeds from the sale of the current COA property be used to reimburse the county.
So moved.
Support.
Motion by Hatfield, support by Getty, to approve up to $200,000 to support the change in the driveway location to allow for future development at the county property west of Harvest Point, with the stipulation that the proceeds from the sale of the current COA property be used to reimburse the county.
Mr. Chair,
Yes.
I just have one question about it. So, I mean, obviously, that's in the future, the sale of COA property. Where does the money come from now?
We'll take it from reserves.
Okay. If there are no further questions, Madam Clerk, would you call the roll?
Getty,
Aye.
Smoker,
Aye.
Jennison,
Aye.
Bassett,
Aye.
Carlton,
Aye.
Campbell,
Aye.
Hatfield,
Aye.
and Jackson.
Aye. The motion is approved. Thank you, Eric.
Thank you, Mr. Chairman.
Tori. Next up on our agenda, we have an appeal, a FOIA appeal from Jeffrey Snowden. Is he with us this morning? Okay, good morning.
I'll introduce them, and then we'll turn it over to you, sir. Good. We have had multiple appeals from Mr. Snowden, multiple FOIAs from Mr. Snowden, of which you have 4 appeals that you're reviewing today. One, FOIA 25-176 is specific about bonds, oaths of office, and other types of surety documents. With this FOIA, we did provide our MMRMA policy plus a performance bond. We did a partial denial on the fact that none of the other document and the oaths of office that you requested, and then none of the other documents exist. So per our FOIA policy, if we don't have exact documents that exist, we can't provide them. So he's got an appeal for that aspect of it. He's requesting still the individual surety, but asked a lot of questions, which with FOIA, the process is to ask for documents. It's not a question and answer process. So we provided the documents that were available to that. So he's asking you to appeal that, and I will let him address those with you. The second appeal is for FOIA's 25179, 25180, and 25180B. And this is a excessive fee appeal. When a request is made, there were a number of documents. If you looked in your packet, there's a substantial number of documents requested in each appeal. And our process is we go through IT, we'll review all the information, pull all the emails that are relevant to the appeal, to the FOIA, and then distribute those to the departments for review, for us to determine how long we believe it's going to take us to review the material, redact whatever is necessary to redact. Well, with a number of emails, the number of items that he cited, it's not a short length of time, shall we say. Within the FOIA appeal, within the FOIA response, we gave him an estimated time for each department, which the total for each appeal is $1,900. Per our policy, we also requested a 50% deposit before we would go through and start the redaction and the rest of the work. So he's appealing that aspect. There were a number of other documents within there. He asked for all communication with Cole Stoker. Those were denied based on attorney-client privilege. There are other documents he requested that just don't exist, so we were able to deny those originally. So what the $1,900 per appeal is, the fact that we need to go through and review and redact all this information, and I believe the Sheriff's Department, if you look at it, they have the most time involved in the process. And you can see all the different individuals, departments, organizations that we do have to go through and review information from. So our stance is, one, in 25-176, we've provided all the information that we have, so we would recommend that you deny the appeal. We'll uphold the partial denial and deny the appeal of FOIA 25-176. And then the other one, our recommendation is to uphold the fee calculation, deny the appeal for the other three FOIAs. I've got the language for the motion here, and happy to answer any questions, or you can allow Mr. Snowden.
How do we get to $1,904.44? Is that based on the broadness of the request of the FOIA?
Yeah, each department reviews what information they would have to go through, number of emails, and they estimate the time it's going to take to go through there. We then request the 50% down. If we go through there and it's less time, obviously we wouldn't charge the whole at that point. But this is our best estimate based on the amount of information that would need to be reviewed by each department.
Is that because of not only attorney-client privilege, but in other cases with the Sheriff's Department and with the prosecuting attorney, there's redactions that are required, so every email has to be read?
Yes.
Vetted, gone
Yes.
through? Okay. There's a calculation per department?
Yes.
Okay.
That is in the FOIA calculation worksheet that's in your packet. It shows each department and how much time is estimated, which the cost of each department's review.
Okay. Mr. Smoker?
If you go through there and it's less time, you say that you would charge less.
We would charge our costs at that point. I mean, but we're looking
If you go
at,
through there and there's more time,
we're still going to charge what we estimate.
okay.
Okay.
Go ahead.
Mr. Colton?
Thank you. Are you able to tell me what Mr. Snowden is trying to get at with these FOIAs?
I will let Mr. Snowden address that with you. But you've got a lot of information in there.
There is a lot. It's a big packet. Other questions before we invite Mr. Snowden up?
I'd say the last thing on your, you have options. You can, with this, I know this is still new to you, you've only done one appeal. You can deny the appeal, uphold the decisions on each cane. You can, or approve the appeal in the 25-176. For the fees, you can uphold the decision in the fee calculation. You can waive the fee, you can reduce the fee. Those are your options at this point. Our recommendation is to apply our policy as we do it to everybody. So that's the calculations you see in your packet.
Mr. Chairman? Eric,
Yes.
would you mind just repeating a recommendation one more time?
Yes, for FOIA 25-176, our recommendation is to uphold the partial denial and deny the appeal. And for the other three, our recommendation is to uphold the fee calculations and deny the appeal.
Thank you, Eric.
Okay, Mr. Snowden. Thank you for coming this morning.
Thank you for having me. All right. Thank you for the opportunity to be heard today. Before I begin, I note that I'm participating today pursuant to Title II of the Americans with Disabilities Act to ensure full and equal access to this proceeding. My name is Jeffrey Allen Snowden II. I'm an Iraq War veteran and a former resident of Berry County. I'm here regarding requests, as Mr. Zuzka said, 25-176, 179, 180, and 180B. At the outset, I want to clarify one important point. These were not FOIA-only requests, okay? They were public records and preservations requests grounded in the Michigan Constitution, Michigan Public Records and Records Retention Statutes, common law rights of public access, and FOIA as a supplemental access mechanism, okay? The county recharacterized these requests as FOIA requests only. That narrowing misstates their legal basis and improperly limits the county's obligations. I'm seeking transparency and lawful compliance. All right, so for 25-176, Michigan law recognizes that public officials may be bonded or covered by financial security instruments. My request sought copies of any public official surety bonds, blanket bonds, or schedules, or written confirmation whether such records exist, identification of the custodian responsible, the statutory authority if such bonds are not required. The county did not produce records, confirm non-existence, identify a custodian, or cite statutory authority. Instead, clarifying correspondence was characterized as a new request. Whether analyzed under FOIA or independent public records obligations, a public body must confirm the existence or non-existence of requested records. A refusal to do so deprives the requester of statutory rights and prevents judicial review. I respectfully request that the board require a lawful response that confirms whether responsive bond records exist, identifies the custodian responsible for those bonds, and cites statutory authority if such bonds are not required. This is a straightforward compliance issue. Moving on to -179, 180, and 180B. These requests seek internal electronic communications and administrative records concerning official conduct and handling of government correspondence. These requests arise not only under FOIA, but also under Michigan records retention laws, court transparency obligations, and preservation duties triggered by reasonably anticipated litigation. The county asserted that responsive communications either do not exist or are exempt from disclosure, while simultaneously charging substantial labor fees to search, review, and redact those same records. These positions cannot logically coexist. If the records do not exist, review and redaction cannot occur. Plain and simple. If records exist, the county must demonstrate that the fees comply with MCL 15.234, including why the costs are necessary, why they are not unreasonably high, and what custodians and systems were searched. No such justification has been provided. FOIA permits cost recovery, not fee barriers that deter access. And so, moving on to the next, improper recharacterization and preservation duties. In addition to access rights, these requests place the county on notice of preservation obligations. Michigan law requires public bodies to maintain and preserve public records. When litigation is reasonably anticipated, preservation duties are heightened. Recharacterizing a preservation and public records demand as a FOIA request does not extinguish those obligations. Transparency and preservation are independent duties. With that, I respectfully request that the board, for request 25-176, require confirmation of whether responsive bond records exist, identify the custodian responsible, and cite statutory authority if such bonds are not required. For 179, 180, and 180B, I request that you waive or substantially reduce the assessed fees, require lawful fee justification compliant with MCL 15.234 if fees are upheld, require a response consistent with Michigan public records law and transparency obligations. I'm not seeking to burden the county. All I'm looking for is clarity, lawful compliance, and transparency in matters concerning public officials and public administration. These principles protect not only requesters, but the integrity of public institutions. Thank you for your time.
Thank you. And I've read through this in detail. It's quite a detailed packet of request of information. And we have, through the last election cycle, that there's always been FOIAs, and some of them have been very numerous, and some of them very expensive to go through, just because of the redactions that are required. I appreciate you taking the time to put together that well-written and well-spoken information, and I would love to have a copy of that, whether you want to email it to me or give me that copy. That'd be great, because I'm not sure that I can answer all the questions with all the statutes and MCLs that are cited. I think there's some legitimate concerns in there. My concern was the broadness of the request with, I think it was 7980, with the time and the redaction going through all of the emails and things like that. Is there any way that we can work with county administration to really narrow down the time frame and what it is? Because the number of departments that you're requesting information from is fairly vast in that time frame. And if we could specifically say, I need it this week or this time or whatever the case is, I mean, I'd love to see that $1,900 be reduced to, way down. The precedence is that if we make an exception for one individual, and by the way, thank you for your service, I really appreciate that, and I appreciate you letting us know that, then we have people in line who do things that just want massive amounts of information, and it does become a burden on the county. So we have to be very careful what we do. But our goal is to serve our constituents the best that we can. And, you've done a really nice job reciting that information. Eric has told us that we don't think some of those records exist in the county, and it may take some time for me as a board chair to look through some of that and decide if this is reasonable, or what reasonable is and how those costs were associated with. But I don't know. Questions from commissioners?
Mr. Chair?
Yes.
Thank you. You wanted to tell me, where do you live now?
I live in Grand Rapids now.
Okay. Are you able to tell me, like you mentioned, maybe probable litigation of some type, are you able to tell me what's going on here?
I'll tell you exactly what's going on. Berry County has an extremely broken judicial system. Extremely broken. And we have a prosecutor in this town who uses their discretion to prosecute cases in an improper way. And then, once they realize that they don't have the support for the charges that they think that they do, they continue to rely on perjurious statements and false testimony and fraudulent charges. They will hide exculpatory evidence and make accusations and assumptions that are just ridiculous. All right? Everybody in this room has a right to be protected by the United States Constitution. And if the Constitution is overriding what the prosecutor is trying to do, the Constitution is the law of the land, not the prosecutor's discretion. Plain and simple, I'm being prosecuted for a crime I did not commit. And I'm being prosecuted maliciously. As a matter of fact, I've filed many, many motions and many, many rebuttals. And then 3 days after I do that and I file a notice of ADA accommodations, the prosecutor moves to have my competency evaluated. Simply because I'm trying to take this to trial and I'm fighting them every step of the way. You're welcome to look up the docket. If you print it out, it's about 44 pages long, I think, because I'm not going to take it lying down. Plain and simple. And this information that I'm looking for is relevant to that. Because there's things going on in this county and y'all's judicial system that need to be stopped, need to be changed. Otherwise, the only thing that's going to be left in Hastings and Berry County is criminals. And that's why I'm doing this. This isn't the first time I've dealt with this in this county, but I'll damn sure make sure it's the last.
Okay.
Pardon my language.
I'm not familiar with the docket.
Like I say, you just looked it up.
Yeah, that's something I could look up or talk to the prosecutor's office about as well. Are there any other questions from the board?
Mr. Chair.
Eric?
We have our representative from Cole Stoker here who can cover some of any questions you may have from the legal standpoint.
Mr. Snowden's gone through.
Jackson if you have any questions.
Yeah. Mr. Snowden's gone through a lot of information, and I don't think a lot of that is familiar to the board with the statutes and the MCLs without some research on it. So I'm not saying that this is the end of the process. If there's information that's relevant that Mr. Snowden needs, the county's been very forthcoming in providing that information. So I'm confident that we're not trying to hide anything from you or take anything away. But I think the reasonable thing for the board to do at this time, I mean, you have two options. You can either table it, or we can deny the request, but then take a look at the information he's provided with administration and see if there is something that we're missing that we can provide and help out with, and maybe narrow the scope of the search to provide the information. So.
I'm more than happy to give you all time to review my documents. Okay? We don't have to make a decision on this today. I'm simply here as part of the process. I do have a question. On January 13th, I mailed out some notices to the Board of Commissioners. I was wondering if y'all had gotten those.
Via email?
No, mail, certified mail, as a matter of fact, and I sent them to you care of the administration.
Okay.
If you haven't gotten them, I have one right here. I brought with me. Matter of fact, I think I got a couple of them. I have those along with, so we got 1, 2, 3 here, along with the, which you asked me to leave for you here today, and just in case anybody says they didn't get it, I've got your mail confirmation right here.
We received it.
But y'all haven't received the information is what I'm gathering from the blank looks.
I get so much mail and so much stuff coming through that I would, and we do rely on county administration to vet some of that mail for us.
Right.
So.
Well, that's fine. I was just curious to know, because there's much more in-depth explanations, everything I just tried to outline today. I'm just trying not to take up too much of y'all's time.
I appreciate that.
So, if you'd like, I can hand this to you.
Please.
Okay.
Thank you. I'm assuming county administration has your contact information?
Absolutely.
Okay. So if there's something we can do to help provide information in here or see, we will look into it. At this point, like I said, I think the request is so broad, that's why the expense is so high on this, and I don't know if there's any way to work with county administration to figure out exactly what you're looking for on it. I sense some frustration with our system that you're dealing with in here, so we'll see what we can do to address that. Board, I don't know if you feel this should be tabled, or we should take a vote on this today and come back to it, take a vote on it. I mean, I think the request from administration is to deny and then review. I think review is the best case on this, to deny and review. But thoughts, input?
I would like to table it because I would like to know more about it before making this decision.
Okay. Is there a question?
I just wanted to indicate to you that you have a 10-day option to extend under the FOIA statute as far as the hearing of the appeal. So you have now 10 business days. That would be the maximum duration that you could wait to make a decision here.
That get us into our next meeting, that would be
No.
10 business
They'll be
days?
passed.
10 business days.
That'll be past our 10 business days.
I would be willing to waive that. If you guys want to take a look at what I've presented to you and take some time and think about it, I'd be willing to waive that extension to the next meeting.
Okay. Advice on the attorney or advice on county administration?
Do you meet every 2 weeks?
Every 2 weeks, the next
It's likely
meeting?
going to be exactly the 10th business day based on the calculation of the law.
So 2 weeks from now? The only issue I'm seeing is it may take longer because I know Eric's going to be out of town and I am leaving out of town after this meeting. So we're not going to have time to delve into this for a minute, but if you can grant us some time.
Absolutely. I'm more than happy to do that because I do want y'all to be as properly informed about the situation as you can be. The only other thing I have to say about this is my requests are rule-based, okay? MCL-based. It's not just FOIA-based. We all have rules that we have to follow, right? That's all I'm asking. I'm being accused of not following the rules. All I'm asking is that y'all follow the rules in return. Everybody, from the top to the bottom.
Okay.
Okay? All right, thank you.
Thank you for your time this morning.
Have a great day.
The chair would entertain a motion to table the FOIA appeal for Mr. Snowden.
I'll make that motion.
Is there support?
Support, Campbell.
Motion by Calton, support by Campbell to table the FOIA appeal from Jeffrey Snowden to be revisited in one of the next two business BOCs. But any further discussion? All those in favor say aye.
Aye. Opposed?
The motion carries.
Thank you.
Thank you. As the chair, I move that we go into closed session in accordance with the Open Meetings Act, Public Act 267 of 1976, 15-268, Section 8C, for strategy and negotiation sessions connected with the negotiation of a collective bargaining agreement. Motion by Jackson, support by Smelker to go into closed session in accordance with the Open Meetings Act, Public Act 267 of 1976, 15.268, Section 8C, for strategy and negotiation sessions connected with negotiations of collective bargaining agreement. Further discussion? Madam Clerk, would you call the roll?
Bassett?
Aye.
Calton?
Aye.
Campbell?
Aye.
Getty?
Aye.
Smelter?
Aye.
Peterson?
Aye.
Hatfield?
Aye.
Aye. We are back in open session. Commissioner Smelker.
Mr. Chair, I move to ratify the total tentative agreement previously ratified by the GELC Berry County Corrections Division and authorize the board chair to sign the successor collective bargaining agreement upon approval as to form by the county attorney.
Is there support?
Support.
Who was that?
Support, Getty.
Okay. Motion by Smelker, support by Getty. Any discussion on the motion? Madam Clerk, would you call the roll?
Carlton.
Aye.
Campbell.
Aye.
Getty.
Aye.
Smelter.
Aye.
Tennyson.
Aye.
Bassett.
Aye.
Hatfield.
Aye.
And Jackson.
Aye. No. The motion is approved. Unfinished business, we have none. New business, we have none. County Administrator's report.
I'll be brief. After this meeting, I'm off until March 9th, so I will have my phones, my email, everything. I will check periodically email, not too often, hopefully. But I do anticipate working on out of state, so y'all, if you do need anything, Jeff is here. I will be here tomorrow.
Thank you.
Well, because it's the only day that works for the mediator, I rearranged some things. That's why I'm leaving right now. We did submit a request for $5 million to the House again for the law enforcement facility, similar to what we did last year. I'm sure we'll get invited back up to do a presentation. We'll see how it goes. And I just got an email from Senator Peters' office about federal dollars, their process opening up, so I will go through that process as well and get something into them. We do need to set a date for the final presentation from the charrette. And the consultants have asked about that, so just make sure, let me know what board meeting you want to.
Okay. And we'll have a conversation about Mr. Snowden and potentially some attorneys' review and opinion on some of that, so
Yes, sir.
the board can better understand that, so.
Yes, sir. But again, if you need anything in my absence, Jeff is here. The well is officially the last day is Thursday. Yeah, no, Friday, 25th is Wednesday. So her official last day is Friday, but she's remote, it's been remote, so. She did send emails out thanking everyone for her gift and the like. But yeah, if there's anything else, I will be around, or reachable at least.
I talked to Luella and told her that she was required to come in so we could ooh and ah over her, or we're going to her house, so.
So if
She has not agreed to that yet, so.
If we find a date that works, we'll do a resolution. But at this point, I'm not holding my breath either.
Okay.
Thank you.
All right, thank you. Chairperson's report, I am all set. Vice Chairperson's report?
I was up in Grand Rapids yesterday for the Michigan Works Board. One thing of local interest, every year Michigan Works hands out the Bev Dutton Essential Service Awards. This award was recognizes frontline employees who work, strengthens our communities and regional economies. There were 6 awards granted this year, one of which came to Berry County. Lehman Johncock, who was a lead cook at Blue Point.
Really?
Recognized. Very nice. Otherwise, I'm afraid most of the news yesterday from Michigan Works was not particularly good because of all the cuts in state and federal funding, a lot of uncertainty. So they're in a wait-and-see mode on a lot of their activities.
Interesting, thank you. Commissioner Campbell?
I guess, boy, it's been a while since we've been here. I was at Johnstown, and they're moving along with their solar development down there, and I do appreciate that Greg does come in every meeting and does a presentation and keeps them updated, so that's all I have.
My electric bill hasn't gone down yet, though. Can you point that out to him?
I've had quite a few that have noticed theirs went up extensively.
Commissioner Tennyson?
I have nothing, Mr. Chair.
Commissioner Smelker?
And quite busy with negotiations and having another one tomorrow. That's fine.
Is this at home or at work here with the unions? Okay, there we go.
There's no negotiation.
Commissioner Getty?
I have Village Midville tonight and Parks on Thursday, so it's a busy week.
Okay, Commissioner Collin?
He was talking about solar panels on the south of the county. Company wants to put in, mainly in Lake Odessa area, but does dip into Woodland Township, about 50 windmills. And they say these cost about $2 million a piece to put up, so $100 million of windmills that would just dip into the northeast corner of Woodland Township. So most of them would be up in Odessa Township.
Is that going to require approval from Berry County Planning and Zoning to make that happen?
I don't know if it's, I'll have to ask about the megawattage. 50 megawatts, isn't that the threshold? Yeah, I'm not sure if it's,
Well, you have the same issue that you do with solar farms. 50 megawatt is the cutoff beyond which they have the option to go directly to the state.
right.
They still also have the option to abide by the local ordinance. So,
I'll have to talk, next, the representative of this company has been going to the Woodland Township meetings. So I'm gonna ask her, you know, what's the megawatts and such.
Yeah, Commissioner Smoker.
Said they put up $2 million windmills, and the solar panels are out how many dollars? Does this have anything to do with equalization? Is that done like a building on property? On equalization? Uh-oh. You don't like it, me.
I'm not going to speak for Mashaya, but there is taxable property. So it is, I know last I talked to her, she was still waiting on data to come in because it'll be construction in progress for this year. But I know she's not anticipating a huge increase in value for '26. I think she was looking at 4% last time I talked to her, after everything was done. So I will have her address those things specifically for you.
Thank you.
When I was in the legislature, I think it was from Hope Township, it was along 43, gentlemen put up a windmill. Older gentleman, always wore this big 10-gallon can.
Yep.
Maybe you know who he is?
Yep.
So his complaint was, he put $50,000 into this windmill, and they then put that on his taxable value, and so he was actually taxed more than this thing saved in electricity.
Interesting.
Yeah, so changes needed to be made in order, you know, if you want people to do that, why would people do that if they're actually gonna lose money in the end?
How many windmills? Or
This-
didn't they say?
This particular gentleman had one, and it was just, I remember seeing it, it wasn't a big one, but up in Lake Odessa, that project's 50 windmills.
I wasn't under the impression that this area of Berry County had that much wind reliance that it would make a difference, but.
In Lake Odessa it would.
Okay.
In Odessa Township, though, weren't they having quite a
Yeah.
talk over that? at
Oh, yeah.
the Board
Yeah.
meeting?
Oh, they've had all kinds of uproar over there.
Well, and the woman from the company, I said, is that a vein of wind? And I guess they've determined that is.
We always heard that part of the county was a little windier. So. Commissioner Bassett.
My Perryville Township meeting was postponed due to illness, but it was late that they postponed it, so I still went. It was interesting because there was a packed house, and many people had come to talk about short-term rentals and what the township was planning to do about that. So we ended up just having some informal conversations about that, and glad I went. Looking forward, I don't know when Perryville will be redone, and the Conservation District is tonight. But I also wanted to recognize Miss Shirley Barnum with 19 years on the ZBA, that is remarkable. So I just
Can't
wanted to
believe she's
thank
quitting
her.
so young.
I know, she's still got a lot in her. But, yeah, I think that's quite an achievement, so I want to thank her for her service.
Absolutely. Okay. Limited public comment at this time. Any member of the public wishing to address the board may do so for up to 3 minutes.
I got great news. I saw a fly over there, that means spring's here. So, we had our church security summit, I forgot to bring this up earlier, last Saturday. Right around 250 people showed up and it was held up at the Middleville Baptist Church, and we also, I forgot the name of the Reformed Church up there. It's just Peace Reform, yes. We extended it on up there, and it's going to be another big hit, so this is like our 9th or 10th year in a row of doing that. So we'll be preparing for the next year's. And let Shirley know we're hiring corrections and law enforcement, so when she gets done with the ZBA, we let me know, right? All right, guys, enjoy your week. All right.
Thank you. Additional public comment? Hearing none, commissioner comments. Commissioner Bassett, back to you.
Okay, so tomorrow night, we do have our first of 2026, the Revitalized Delton meeting. We've moved those to the 4th Wednesday of the month instead of Thursday. So it's tomorrow night at the Delton Kellogg Middle School cafeteria instead of high school because there's district basketball up there. And we have so much exciting news to be presenting, so I'm hoping we have a lot of people show up for a coffee bar or a cocoa bar. There will be cookies as well. And so, we'll be announcing the $1.5 million that was approved for us from MISTA. We've got a couple new businesses that we'll be presenting, their new businesses there, and a couple changes that are happening. Got a building going down, not sure what's going to be happening there. So a lot of announcements. Our Pocket Park, we've got some action on that. So a lot of exciting things, and we'll be presenting them all to the community tomorrow night. So if you want to come for some cocoa, come on out. And then our gala that we're going to be having for DKEF, the Education Foundation, and Rotary, tickets are half sold out, okay? 160 people allowed in. We're close up to about 80 tickets sold already, so if you want your tickets, jump in. That 9/11 survivor presenter, I think, is going to be a huge draw for that event.
What date?
That is April 16th, and I think you already have tickets. I remember. You're on the list, I think. And that's all I have.
Mr. Colton?
Tomorrow, we're kicking off with a Nashville Garden meeting, talk about what we're going to do for this year.
Okay. Commissioner Gay?
I'll be there for the garden meeting, and we're doing the same in Delton, so spring is on its way for sure, flies or not.
There you go. Commissioner Smoker? Commissioner Hatfield?
Nothing else.
Commissioner Campbell?
I'm good.
A man of few words.
I'm good, too.
Commissioner Tunison?
I'm good.
I want to thank Commissioner Smelker for his effort in these negotiations process that, well, we've been doing this over 6 months. I mean, I think we started middle of last year, so we're probably heading towards 8 months here. John's been putting in extra time to make this stuff happen. I think we've got a fair agreement, and hopefully that's a model that'll serve the rest of the county and county employees and unions well that we can move forward with. So thank you, Commissioner Smelker, for your time, effort, and energy, as well as county administration and our attorneys who's helped guide the process as well.
Thank you, Matt.
So, thank you, Matt. So, and this is the last meeting of the month. So, on behalf of county administration, if you plan on putting in your mileage request, do it early, surprise somebody.